Well, my mandate is exclusively about his conditions of detention and not about whether, he was properly prosecuted or not. I have no opinion on that. And, of course, I have no opinion on whether on his plea or his guilty plea. But obviously, if in a given situation someone is forced to plead guilty, that would be tantamount to a forced confession, and that, of course, is prohibited by international law. In this circumstance, I am persuaded that he was unjustly put in solitary confinement for 8 months at the beginning of his detention, and that constitutes a serious violation by the United States of its obligations under international law, including the Convention Against Torture. But I also know for a fact that he has not been in solitary confinement for the last 18 months or so. It's difficult to say that his previous solitary confinement had any bearing on his decision to plead guilty right now. Without more information on that, I wouldn't venture that hypothesis. It doesn't seem right. I mean, if he had pleaded guilty while being held in solitary confinement, that of course would be a serious consideration. But he's been in the regular prison population of Fort Leavenworth for now 18 months, and he's been communicating with his lawyer and all that. So I don't see how it could have a bearing on his decision to plead guilty.